Yes, Mr. Fripp.
Yeah.
Can we begin?
I'm so sorry, my lad. I didn't mean to.
May we begin by just satisfying ourselves that the arrangements are secure in terms of anonymization?
My lad, I've been shown the image from the video camera. My lay client is sitting behind my solicitor. He cannot be seen on the video feed, and that side of the court cannot be seen on the video feed. And he has seen that.
And you're content, are you? You and he are content.
I'm content.
Sometimes we've had cases, I know, when the litigant in person has sat, or the litigant has sat in the back row, right at the back of court. But if you're content with the arrangements, that's fine so far as we're concerned.
I am, my lad, and we're grateful to the court.
Okay. We're being live streamed. We must all do our best to ensure that the anonymity of your client is maintained. The country with which we're concerned will be named, won't it, Mr. Fripp?
It will, my lad.
It'll have to be. But your clients will not be named.
My lad, if I have occasion to name third parties, for example, within the organisation, say perhaps with one exception, I'll seek to say Mr. X or to refer by initials.
Well, there is a time. If there is a slip, there is a time lag. So there will be an opportunity for something to be done about it. But I think let's all do our best to make sure that anonymity is preserved.
Well, my lad, I'm
and so that you know, we have read the relevant judgments. We've read and we've read the skeleton arguments.
My lad, I'm very
and
grateful.
I can't say for my part I'm absolutely on top of the political history as set out in the UT judgment, but I have, for my part, I have a broad understanding of what's involved.
Thank you, my lad.
Thank you also for your time estimates. We thought that we are, for our part, we're confident we can complete the case within the time that you've allowed.
Well, my learned friend and I feel the same, and we'll try to make that good.
Right.
Well, my lad, some housekeeping, if I may. May it please the court, I appear with Mr. Theo Lester for the appellant, instructed by Messrs. Morgan Solicitors. My learned friend, Mr. Jack Holborn, appears for the Secretary of State, instructed by the GLD. And following the suggestion of the court to preserve anonymity, we have reversed the conventional and seeking plan. My lad, as to documents, the court referred to the skeletons on both sides. You should have a trial bundle, including a core bundle of 212 pages, a supplementary bundle.
We put them all. I put them all in one bundle. But we have,
Thank you, my lad. And your lordships should have an authorities bundle of 12 tabs, A to L.
Yes.
In addition, my lad, there are two authorities to which I'll make reference in submissions. Copies of those have been provided to my learned friend. They're YH and the decision in the Siva Kumar case in the Court of Appeal. So the court should have those.
Thank you.
My lad, the court has counsel's estimate on time. I'm going to address the matter, if I may, in the following section. 5 sections. And the first 3, I hope, relatively brief. The first section will be a brief introduction. The second section will be the issues in the case and the appellant's position. The third section will be the relevant law. My lad, I can indicate for the convenience of the court, this is a case in our submission which we accept doesn't raise a new issue of law. but it raises important issues of law concerning the application of principles on which there has been decision by the court in two particular contexts, which I'll reach when I've identified the issues. The fourth section, I'll deal with the factual and legal background, and that's likely to be the longest section, because to some extent our complaint of the decision we appeal against, the decision of the upper tribunal, arises organically from that. And my submission, which will be the final section, may be relatively shorter than the background.
Thank you.
Malad, in introduction, this is our appeal, and it's our appeal from the decision of the upper tribunal promulgated on 30th of March 2022. The appellant is a citizen of Pakistan. He's a member of a political organization, Muttahida, the Muttahida Qawmi Movement, or MQM, which has previously been known as the Muhajir Qawmi Movement. That organization has been powerful in the Sindh region of Pakistan. It split in 2016. The appellant is, it's accepted in the case, a member of the organization as it exists in the UK. This part of the organization proclaims loyalty to the founder and longtime leader of MQM, a man called Altaf Hussain. And so MQM, its basic political origin is as a Sindhi nationalist political project representing Sindhis within the province of Sindh in southern Pakistan in the ethnic politics that's prevalent there.
Yes.
There's, following a split in 2016, there's a different leadership that asserts its leadership of MQM in Pakistan and has split from Altaf Hussain.
Yes.
Malad, the appellant has been in the UK from June 2012, initially as a student and in various capacities. At one point, his leave was curtailed because of a problem with his student status, but he was able to apply, make an application. In practice, he maintained lawful presence until at least 16th of February 2016, when his application to stay on the basis of a marriage to a British citizen that subsequently failed was refused. So he was lawfully present until early 2016. He sought international protection and asylum on the 19th of October 2017. That was refused on the 18th of April 2018. I'll deal with the incidents of this in the background. And his appeal was dismissed by a first-tier tribunal judge, Judge Scahan, in the determination that was
Date of that?
That was promulgated, Malad, on 27th of June 2017.
The dismissal?
The dismissal by FTTJ.
Sure about that? Sure about that year?
Let me, if I may, look to the original item.
I think you said
and
it was...
I'm not, in fact.
It was
it's a mistyping, and it's 2018.
Yes, so
Your Lordship.
he made the application 19th of October 2017. It was refused the 18th of April 2018, and his appeal was dismissed by the FTT on the 27th of June 2018. Is that right?
Yes, and an interesting perspective on that is that it shows how rapidly the system was able to move in as recently as 2018, you know, from decision to appeal within a short period of months. The appellant made further submissions which were refused, but they were treated as a fresh claim under the Para 353 immigration rules rubric, which I'm sure will be familiar to the court. So a realistic prospect of success, and that meant that he could appeal the new refusal, and that appeal was dismissed by first-tier tribunal judge Henderson by a decision promulgated on the 5th of February 2020. And that decision is in the core bundle, page 126. That is that decision. The appellant sought and was granted permission to appeal from that to the upper tribunal. The upper tribunal set aside Judge Henderson's decision, in part preserving some findings by Judge Henderson, and the upper tribunal ultimately reheard it. That is the decision from which we appeal.
And the date of that is, as you've already told us, the 30th of March.
It is, of 22. And that determination begins at page 59 in the core bundle.
Yeah.
The appellant was refused permission to appeal to the Court of Appeal by the UT, renewed that, and permission to appeal was granted on 2 of the 4 grounds pleaded.
Yes.
By Lady Justice Asplin, by an order stamped on the 3rd of February 2023. I've indicated that there were 4 grounds. There's no renewal of the 2 grounds on which permission was refused. So what was the 4th ground, I'll refer to, if I may, as the 2nd ground. So the issues in the case, each arises from one of the 2 grounds on which permission was granted. The first issue was the tribunal's assessment of risk, that the tribunal being the UT on the rehearing, was the UT's assessment of risk arising from the appellant's activities in the UK, referred to as surplus activities, legally adequate. In particular, given the UT's acceptance of many aspects, both of the appellant's evidence as to interest and activity by the Pakistani authorities, and acceptance of significant facts concerning the appellant's activities, did the UT err on its way to the conclusion that there wasn't a reasonable likelihood, not even a reasonable likelihood, that is the lower standard of proof applicable in asylum, of the Pakistani authorities being aware of the appellant as involved, and therefore possessing a well-founded fear of persecution if returned. The UT did come to a settled view that if he was identified as a member of this organization, he would face a well-founded, he would possess a well-founded fear of persecution in Pakistan. The second, and so our case is that given...
On the first issue.
On the first issue. Our case on the first issue is that given acceptance of prior activity and allegiance to the MQM, that is prior to the split in 2016 and within MQM, and prior to his asylum claim in 2017, and given the other facts that were accepted about the appellant and the UT's findings about Pakistani government efforts to identify supporters of this group in London, the upper tribunal erred in concluding that the appellant didn't face relevant risk of persecution by reason of the activities he'd taken part in, essentially since 2016, since the split within MQM. In particular, the UT erred in concluding, inconsistently with the direction of its own findings, that there wasn't a reasonable likelihood of the authorities being aware of the appellant as involved in the group. On the second issue was the upper tribunal's assessment of the appellant's attitudes as regards MQM and AH. That the
of his, did you say attitudes?
Yes. You could say his mens rea. And this is essentially about his allegiance.
Okay.
And that's because...
I interrupted you right and finished the... Forgive me. I rudely and unhelpfully interrupted your exposition of the issue. So why don't you just tell us what the issue is then?
Yes. The issue...
was the UT's assessment of his attitude?
Yes. Well, the UT came to the view, the UT came to the view that the appellant was, his involvement with MQM was purely cynical. That is, that it was a masquerade carried on solely to gain asylum. I mean, that's a paraphrase.
Yes, neither of those words appear in the judgment.
No, but it's a
masquerade.
Yeah, it's necessary to their conclusion that be the meaning of what they said when they said he's not a genuine supporter.
Yeah.
Of the organisation.
He exaggerated his role in order to support his asylum claim. That's it, isn't it? That's what you say they found.
Yes, and
yep.
we parts of his evidence, in particular over time, his claim that his family had been approached in Pakistan by the security authorities was found not credible.
Yes. So you haven't completed. And again, it's my fault for interrupting your first sentence under 2. But the issue is, was there assessment of his attitude? How do you put it?
Well,
are you saying right, correct, sustainable, supported by the evidence? What is the issue? How would you characterise it?
Was the UT's assessment of the appellant's linkage to MQM as not genuine,
right,
legally adequate, is perhaps...
Legally adequate?
Yes. And this was a relatively short, as it were, onward finding, 2 paragraphs at the end of the Upper Tribunal's reflections, having dealt with other issues, as to whether he would face a deprivation of the right to express his protected identity as a supporter of MQM. And the only basis on which he could be denied asylum would be if he doesn't actually have any protected identity. That is, he isn't a supporter or a genuine supporter to any degree of MQM.
May I answer that? On the face of it, it seems that is a finding of fact. Are you saying it's not a finding of fact?
It is a finding of fact, and the ground goes to the fairness and adequacy of the process, whether the UT took into account matters which it should have taken into account, and whether it at any point expresses adequate reasons for a view that represents quite a dramatic shift from any previous view, because various aspects of the appellant's claim have been believed, other aspects have been disbelieved, but it had never been said, there had never been a judicial finding before that point, at the end of the UT's determination, that this is someone who doesn't have any genuine attachment at all to the party he's been a member of for a considerable number of years.
If you succeed, what are you asking this court to do?
On the first ground, it would be open to the court, if the court is with me, to allow the appeal outright on the basis that on the evidence, on the findings of the UT concerning the efforts and capabilities of the Pakistani authorities, there wasn't a basis to conclude that there was not even a reasonable likelihood they would be aware of the appellant as a member of this organisation. But it would be a matter of judgment for the court whether to allow it outright or whether to remit for a narrow and focused supplementary rehearing on the point before the...
On one?
On one.
If we were against you on one but with you on 2?
Then I accept that the highest relief could go would be remittal, because the issue hasn't been adequately addressed, but I accept that a conclusion is not dictated, a conclusion my way is not dictated by other material.
Thank you. Right, so that's issues and your case, is it?
Yes, and that is our case. I move to the relevant law.
Yes.
Much of this may be well known to the tribunal. I'm so sorry. The court.
We are a sort of tribunal.
Well,
Tribunal in a general sense. Not specific.
Well, of course. My lad, I'll try to deal with this relatively swiftly to come to the nub, which is really what happens in the specific case and our submissions on that. But as a general proposition, of course, the refugee definition, Article 182, can be encapsulated as someone has a well-founded fear of persecution for a relevant reason. Those reasons include political opinion and is unable or unwilling to return to, I use the male gender because the appellant here is male, to his own country by reason of such fear.
Yeah.
In two well-known authorities, H.J. Iran and R.T. Zimbabwe, a wrinkle on that has been addressed, and that wrinkle is the degree to which individuals can be expected, well, individuals are excluded from the refugee definition if through fear of persecution they would conceal the protected characteristic. That is, they would conceal their sexuality, was the instance in H.J., or they would conceal their political opinion, or they would fake another political opinion to avoid persecution. That was the issue in R.T. Here, of course, it's political opinion. Now, I could take the court to the key references, which in H.J. are Lord Roger at 82 and Lord Hope at paragraph 35, but it may be that the matter is so well known that I can move to...
Yes, we don't need you to go to either of those cases, thank you.
Well, I'm very grateful, my love. There's a further decision in a case called W.A. Pakistan. The W.A. Pakistan was an Ahmadi case, and there had been country guidance about Ahmadis.
Yes.
And part of that, which had distilled in from a decision of the CJEU relating to gay men, was that there had to be particular importance. And that was distilled by the upper tribunal in the Ahmadi country guidance to being the protected characteristic. Its open expression has to be of particular importance to the individual. And I'm very happy to take the court to this, but that was rejected by a panel of this court in W.A. Pakistan.
Do you want just to show us the paragraph to which you need, I think, spend long on this, but just so that we, for our note, know precisely what it is you're alluding to?
Yes, I shall. And that is at C, and the judgment is that of Lord Justice Irwin.
Yes.
And at para 60.
Forgive me, Mr. I'm trying to work electronically, so if you give me a page number.
121.
Yes, I'll see.
In the hard copy.
Both page numbers. It's 121
same.
in the universal pagination.
We'll just see if it's universal, Mr. Pritt. Maybe. Same? 1, 2. They're the same. 121. Good.
Yeah. I'll use universal pagination for the convenience of the court whenever I can.
That's fine.
I'm grateful.
Thank you.
So, para 60, Lord Justice Irwin, having dealt with the issues, is coming to what the correct guidance ought to be in relation to the questions raised, the questions that were identified in HJ as the questions that have to be asked. And he identified the questions. Small room 1, is the claimant genuinely an Ahmadi?
Shall we just read this for ourselves?
Certainly.
Thank you.
Thank you.
Oh, this is basically an exposition of the HJ around test, isn't it?
Yes, and it's particularly the final three sentences of subpara small Roman 3 that have bearing here in my respective submission. In essence, there's no requirement that public expression of the religious faith
Thank
of
you.
a kind likely to attract persecution should be of particular importance. And we would say the same principle applies equally to political opinion. It's an elaboration of the principle in HJHT, or that's how Lord Justice Owen phrases it. It's also consistent with what the Supreme Court had said in R.T. Zimbabwe, which was that the strong holder of a belief and the lukewarm holder of a belief are equally protected because it's the nature of the protected right that determines what is persecution.
Thank you.
And so,
Where do we go from here? What's the next
from
authority?
here, my lad, of course, it's there are a number of authorities dealing with the assessment of surplus activities in where claims are to protection are made. The first of those is the decision in Danian at tab H in the authorities bundle. The key question in Danian was whether, as was submitted for the Secretary of State in that case, there was essentially a bad faith exception to the convention, whether someone who engages in activity in bad faith to try to get asylum in the UK is excluded by the fact of the bad faith from being recognised as a refugee. And that, so Mr. Danian was such a case. He was a Nigerian national. He had been refused asylum and he took part in demonstrations. And his case was that the participation in further demonstrations put him at risk. That was found to be activity he had engaged in bad faith to try to secure his position in the UK. The essential parts of the judgment are those of Lord Justice Buxton in the, I'm so sorry, I don't have a universal page here.
Nor do I.
It hasn't shown up.
No, I'm afraid there's a bit of a gap.
I'm so sorry.
The report page.
The report page is 559. And neither of you have letters on the edge. But
No.
the key passage
Well, it might be the bit at the bottom of the page. Is that where you're going to go?
yes, if I mean the court could take it from the Secretary of State's contention, which is about 2/3 of the way down the page.
By the second whole
But
page.
it becomes more intensely important.
Notional second, virtual second whole page. Okay. Secretary of State's contention was
Yes,
of 2/3 of the way down 559. Yes.
yeah. If he'd acted in bad faith, he wasn't a convention refugee. And so that's the submission that's being considered here. Lord Justice Buxton turns to that. The general term bad faith is susceptible of a range of meanings and applications, a matter to which I'll have to return. But it sets out what Mr. Kovacs has submitted about that. And two comments. First, the IAT didn't approach the matter in those clear terms, saying that there was essentially an ouster, but they did seem to have attached considerable importance to bad faith. And the second point of Lord Justice Buxton is one which we would say has some wider parallel in this case also. Secondly, where there is, as Lord Justice Brooke has demonstrated in this case, a long history of opposition to the regime of a particular country, albeit expressed.
This is top of 560.
Yeah,
560.
560.
560.
Paragraph beginning second.
Second. Yes.
and without bringing it to the attention of the authorities, it's very difficult to decide what, if any, part of that history should be excluded from the acting of the applicant. So if one tries to, as it were, enact a bad faith ouster, it's very difficult to tell at what point you exclude from relevance activities an individual has engaged in, especially when there's earlier activity. And the instant case is one where even on the UT's conclusion, although it, we would say doesn't deal with this adequately in relation to the ultimate issues, the appellant had been active, or the appellant had been involved in and supporting the MQM and Altaf Hussein before he ceased to have secure immigration status, and substantially before he claimed asylum. So the UT accepted there was evidence of involvement in 2013, 4 years before the claim of asylum. So, but Lord Justice Buxton makes that reference to the difficulty of deciding. And what that goes to, in a way, in this case is, this is a man who, even on the UT's conclusion, and I'll bring the court to something else, even on the UT's conclusion, was active or was linked to, in a material way, I'll get to the exact language, for 4 years before he claimed asylum. And we'd respectfully say that when the UT came to both of the issues which underlie grounds of appeal, the fact of earlier activity should have been given adequate weight and should have been dealt with in a legally adequate way. But before I move from Damien, I mean, the passage after secondly, Lord Justice Buxton, halfway through this paragraph, the paragraph begins, even if therefore.
Yeah.
But the nub is, in the event, however, I'm of opinion that the Secretary of State is wrong to contend for any bad faith term or limitation in the application of the Convention. And then he goes on to explain why that is, but it's not contested, as I understand it. This is now established law, that there is no bad faith exception in the Convention applied in this jurisdiction or generally as a matter of interpretation of the international instrument.
Well, how far does that get you? If, as a matter of fact, I see. So you're saying that okay, I've got the point. Well, insofar as he has acted in a way which would jeopardize him, were he to go back, that even if he had done so the fact that he had done so for the purposes of securing his asylum claim is irrelevant.
Yes, I mean, as the next authority demonstrates, and in Iftikhar Ahmed, your lordships and leadership have Iftikhar Ahmed at tab G, and decided after Damien, but in fact, with a universal reference that's prior to the Damien reference, for whatever reason. The key, and I'm so sorry, I've written on as what should be the universal reference to the page 168, but I'm not sure that appears anywhere.
It doesn't on the bundle.
It's page 7 of the report, and at the foot of page 7 of the report. And so, my lords, my lady, this is Lord Justice Simon Brown, as he then was, and he helpfully encapsulates, as he sees it, the nub of Damien at the beginning of the paragraph that begins essentially. Essentially what Damien decides is that in all asylum cases, there's ultimately but a single question to be asked. Is there a serious risk that on return the applicant would be persecuted for convention reasons. If there is, he's entitled to asylum. It matters not whether this arises from his own conduct in this country, however unreasonable. It does not even matter whether he's cynically sought to enhance his prospects of asylum by creating the very risk on which he then relies. Cases sometimes characterized as involving bad faith. When I say that none of this matters, what I mean is that none of it forfeits the right to refugee status, provided only and always that he establishes a well-founded fear of persecution abroad. Briefly, the facts of Iftikhar Ahmed were somewhat different from Damien. Damien was plainly a bad faith case.
Sorry, I just think the next sentence should be better. She's a very important writer.
I'm certainly...
Where did you stop?
Yes, well, I'm very
Where
happy
did you
to read
stop?
on. It's at the top of page 8. So, the sentence before,
yes.
when I say that none of this matters, what I mean is none of it forfeits the applicant's right to refugee status, provided only and always that he establishes a well-founded fear of persecution abroad. Any such conduct is, of course, highly relevant when it comes to evaluating the claim on its merits, i.e. to determining whether in truth the applicant is at risk of persecution abroad. Any applicant who has behaved in this way may not readily be believed as to his future fears. And then...
Yes, thank you.
Yes?
Well, there's no suggestion the upper tribunal fell foul of any of this in relation to the ground one issue, is there? This just wasn't a factor in their reasoning.
No, this wasn't a factor in ground one at all, and this goes to ground two, ultimately.
But that's a different question, though, isn't it, ground two?
Yes, ground two is the,
These authorities are not relevant to that.
The risk question. Ground two is the assessment of motivation.
Attitude, to use your word.
Of attitude, or mens rea, why he's supporting.
These authorities are not addressing that.
Whether he's genuine or not genuine. No, I mean here, Iftikhar Ahmed, in Iftikhar Ahmed, the appellant was an Ahmadi from Pakistan, from the Ahmadi religious group, who said, I will proselytize because this is my conviction that I have to do this. And it was accepted that he was saying this in good faith. But the question was, as it were, voluntary activity that would bring the risk of persecution on someone, and whether that raised some exception, or whether that was akin to...
Which doesn't arise in this case.
Yeah, that doesn't arise in this case. We say in this case that the upper tribunal doesn't deal adequately with the issue of what the motivation is. They say he's not a genuine supporter.
Well, you'll come on to this when you...
I will.
So that's Iftikhar Ahmed. What other authorities, if any, do you want us to look at?
Well, at tab D, the court has the decision in
Burma?
Burma,
Yeah.
the Court of Appeal. So that concerned the challenge to country guidance, which itself looked at the position of individuals and surplus activity in the country. In that case, Burma. There are two groups referred to. One is failed asylum seekers and the other is hangers-on. So hangers-on were people who were self-affiliated to the demonstrators, but were considered to have no conviction. They were, as it were, not genuine oppositionists, if one takes the parallel out from this case. And there it was said, the key passages are on the universal page should be 137. In the report, it's page 787, and it's the judgment of Lord Justice Morris Kay. Of course, these cases are different. This was about the situation where individuals had been photographed outside the Burmese embassy whether the Burmese authorities had the means to identify them, and it was the upper tribunal accepted evidence of photography and identification, but the UT considered then that there wasn't a risk to those who were hangers-on because the Burmese would realize that those people were not genuine supporters of the opposition to the I think, army regime. And that's dealt with at para 31, page 787 of the report.
Right.
And there's reference to the inherent difficulty of assessing risk arising from surplus activity in the case of a hanger-on. That's at para 32. One other point which the court might note in relation to the question, I mean, one question was whether the Burmese authorities operated an assessment system that said, well, this is a hanger-on, this is a serious oppositionist, and worked against people on that basis. But quite an important point, of course, in general and paralleling that, is that, I mean, depending on the circumstances, targeting hangers-on may be something the state does, either because it uses them for intelligence on other people, or because it is interested in deterrence, and deterrence is accomplished by targeting hangers-on. It discourages other people from being hangers-on and from aiding oppositionists. Finally, there is...
It's worth noting, though, on that case, at the bottom of paragraph 30, that the upper tribunal accepted the evidence of routine photography and video recording of demonstrations outside the embassy.
Yes.
And of efficient identification processes,
yes,
which resulted in the relaying of information to Burma.
Factually, yes. Factually, it's different, and I fully accept that, and I have to address when we come to the background of this case, the situation as regards Pakistan and MQM-L supporters.
Yes.
I should have said, supporters of Altaf Hussein don't, as it were, accept that there's been a split, but they're often, but for understanding, I'll refer to them as MQM-L, which is how they're referred to externally by very many people, to denote, as it were, the faction that it remains loyal to, Altaf Hussein based in London, MQM brackets London.
Okay. What was the legal principle that you were trying to draw from KS Burma?
The legal principle is the susceptibility to appeal or review of this sort of judgment by the UT concerning the assessment and the scope for discrimination by the authorities in surplus situations.
But that's not a legal principle, is it?
And Para 31 particularly, no, I accept it's a matter of approach. Para 31 particularly, the 31 ascription of potential for a rational, careful assessment, and indeed for a certain motive of distinguishing genuine individuals rather than operating deterrence and gaining intelligence.
So this isn't so much a principle of law as a criticism of the approach of the upper tribunal to the facts of that case?
I'd accept that, milady. It's an example of an incorrect approach.
Okay.
But the factual finding in this case is that the activities of the appellant would not have come to the attention of the Pakistani authorities.
Yes, and the route, my lad, the route by which the upper tribunal get to that, in my respectful submission, collides or attaches too little weight to important issues about the motivation and competence.
Okay. Well, we're going to come to this all when you get to your case.
Of the Pakistani
All right.
authorities.
So have we now dealt with KS Burma?
Yeah.
You were going to take us back to Tam.
And I'll take the court to YB Eritrea.
Yes, this is Lord Justice Sedley.
Yes,
We do have universal numbers here.
divider E. And this was, again, another surplus situation. Might I ask the court to read paragraph 18, which is on page 147?
Yes. I confess, and I do so with great hesitation, Mr. Friend, I'm a bit puzzled by this paragraph. In particular, the lines, the phrase, it requires little or no evidence or speculation to arrive at a strong possibility, and perhaps more.
Yeah. Well, my lad, I'd tend to, I'd suggest that the gist there is that where you have authorities who have capability and motivation, and where the motivation is the suppression of political opponents, so that reference by Lord Justice Sedley, where you have that, elevating your standard of proof to demand that an individual show that he or she is under surveillance by the state, may represent a fetter on the correct approach, and that's our case. That's an important part of our first issue.
I mean, the activities, and you'll tell me if you think this is simple-minded, the activities of countries, and I'm looking particularly at foreign legations, the point in the middle of that paragraph.
Yes.
The activities of foreign countries vary, don't they?
They do.
And whatever, how many states there are in the world, 196, whatever it is. One can imagine some countries with well-resourced embassies conducting observation of this sort, whereas others would not.
Yes.
And actually, it probably doesn't matter whether they're politically suppressive, that's the right word. I dare say many democracies have legations which conduct surveillance of those who stand outside their embassies.
Yes, no doubt, against a different background of law and human rights observance in those cases. Well,
what was the evidence in that case about whether or not surveillance was going on?
by the Eritreans, my lady.
Yes. What were the facts? I mean, there's a long citation in paragraph 7 of Lord Justice Sedley's judgment. I'm just looking at it now. the tribunal said Mr. Phillips was not able to point to any authorities or objective material which indicated the authorities in Eritrea have the means and the inclinations to monitor activities of expatriates in the United Kingdom, particularly those who operate from Newcastle. Was there any evidence at all that photographing was going on?
Well,
there's a sentence towards the bottom of the page that says, even if photographs were taken, blah, blah, blah. Is that speculation, or was there evidence that photographs were taken?
The decision was 15 years ago.
Yeah.
Milady, I can only take it from the judgment that there was essentially no evidence that it was an inference the tribunal was asked to draw from the fact of repressive motivation.
So are you inviting us to... I mean, I just don't understand what, with all due respect to the Justice Secretary, I don't understand what he's deciding in paragraph 18. Is this a proposition of law that a tribunal is obliged as a matter of law to find, even when there's no evidence about it, that seal class activities are monitored and reported back? I just want to understand what paragraph 18 means.
Yes. Well, Milady, our submission is that the judgment as to whether seal class activity gives rise to risk involves certain important considerations. It involves the capability of the state and the capability of the Pakistanis in London on the evidence.
No, I'm not asking you... Sorry, Mr. Fripp, it's my fault. I'm not making myself clear. I'm not asking you about the facts of this case. I'm asking you about what paragraph 18 decides, because I want to know whether you're submitting that we're bound by some proposition of law that's enunciated in paragraph 18. And if so, what is it?
I'd make the same admission I made in answer to your question concerning the last authority. That it's an illustration of a legal approach. And the legal approach, or the guidance, if I can put it that way, that can be drawn from this is that it's important that there can be cases for inference from the means of surveillance and interest in surveillance by an undemocratic regime, or a regime who are interested in oppositionists in the UK.
But so is a tribunal bound to find, even if there's no evidence to support such a finding, but because it's a repressive regime, yes, it's going to be monitoring its activities of people who oppose it abroad. And I just want to get to grips with what your submission is about this.
Yes. My submission is that Lord Justice Sedley is saying the situation has to be looked at in the round. There may not be, people may not be issued with certificates by the Eritrean consulate or the Pakistani embassy or whoever to say, we're monitoring you. You should be aware of this, and that the initial aspects may be sufficient to enable an inference. And we'd say we're a very different case from YB outside the Eritrean consulate in Newcastle, or even the Eritrean embassy, because of the evidence that was before the UT.
Okay.
I think because of the findings of the UT.
Well, so on the one hand, it may be that the AIT would have been justified on this approach to hold that this was going on, even though there was little evidence. But are you saying that the upper tribunal in this case was required to find that this was going on the facts of this case?
I'm saying, Milady, that the UT's, the evidence before the UT and the UT's own findings on that about the level of interest by the Pakistanis in this group and in Altaf Hussein, and the level of capability, of capacity applied to this task by the Pakistanis meant that there was substantial basis for inference that someone who was involved in the party for a number of years would be known to the...
In order to overturn their finding, though, you've got to go further than that.
Yeah.
You've got to say that it's an instance they had to draw.
My submission is that certainly the route by which they get to that, I'll deal with it, if I may, primarily in the submission, but the route by which they get to their conclusion is one that is inconsistent with certain of their own findings and inconsistent with evidence that they accepted.
I think, in common with my lady, I'm just a little bit unsure what these authorities are really adding to what will be the nuts and bolts of it. Is looking at what was the evidence and what was their analysis of it.
Yes. Well,
May I just say, it seems to me that the important thing in these authorities, and particularly in this one, it is the very specific issue, which you see at the bottom of paragraph 3, which is, it was asserted that he had taken part in public demonstrations outside the embassy, exposing himself to identification and ill treatment. And that seems to me was the issue. But in that case, would the Eritrean authorities have identified him from the fact that he was demonstrating outside the embassy? As I understand it, what Lord Justice said is saying is it's naive to think that repressive regimes wouldn't be looking at who was demonstrating outside their embassy.
yeah.
That's as far as I think it goes.
Yes, and I'd accept, if I may, I'd respectfully accept that account of it.
There's no suggestion here that the appellant ever demonstrated outside an embassy.
Well, there is evidence here the appellant has taken part in demonstrations, and the upper tribunal accepted that evidence.
Were there demonstrations outside the embassy?
I'd have to take instructions. The finding.
No, point is the evidence.
Yeah.
It's
not a question about instructions. I mean, what was the evidence? Was there any evidence before the FTC or the tribunal that the appellant had demonstrated outside the Pakistani embassy?
My lady, let me, if I may.
I'm just conscious that we're slightly leading you away, because this is actually the kernel of the case.
Yes.
Or one of the kernels of the case. And I'm very conscious of the time. We've had half the time that you said you were going to take.
Yeah.
I don't know whether that's on target or not. Bear in mind what you said, point 5 is likely to be your big point.
Yeah.
Have you finished with the authorities?
Yes.
Eritrea is asking.
If I can identify the evidence about the demonstration.
Yes, do that.
Into the background. Among the other authorities, the tribunal, the court has 3 authorities relating to the effect of previous adjudication. Jabbar, Devaseel, UK, Afghanistan. What that establishes essentially is that a previous final decision represents the starting point for what follows, although another tribunal can depart from it for good reason. Of course, the authorities, I passed up authorities relating to anxious scrutiny, because in asylum, it's been said since the decision of the Lordship's House in Kogdiki in 1987 that asylum cases call for most anxious scrutiny.
Yeah.
What's been said about that, Lord Justice Dyson and Siva Kumar, paragraph 30, Lord Justice Thorpe and Mr. Justice Wright concurring, that is not a mantra to which only lip service should be paid. It recognizes the fact that what's at stake in these cases is fundamental human rights. that's para 30 in C. Kumar, and a YH decision. Lord Justice Conrock, as he then was, referring to anxious scrutiny again, at para 23 in YH, he said, having described the origin of the phrase, it since gained a formulaic significance, extending generally to asylum and Article 3 claims. And para 24, the expression in itself is uninformative. Read literally, the words are descriptive not of a legal principle but of a state of mind, one which might be thought an axiomatic part of any judicial process, whether or not involving asylum and human rights. However, it has by usage acquired special significance as underlining the very special human context in which such cases are brought, and a need for decision to show by their reason that every factor which might tell in favour of the applicant has been taken into account. And there's a passage after that Mr. Oberon would want me to identify, which is that he went on...
Which paragraph are you on now?
And para 24.
Thank you.
YA.
On 456.
Yeah, there's a balance in this draft, yes. So anxious scrutiny may work both ways.
Yes.
It doesn't favour undue credulity towards those advancing stories which are manifestly contrived or riddled with inconsistencies. Let me move now to the background, if I may. I'll take this through the skeleton argument. Your Lordship kindly indicated that the tribunal have read the factual background, and so
yes.
I shan't retail that. I'll seek to deal primarily with the decisions. Your Lordships and Ladyship have the political background at paras 6 to 8 in the skeleton.
No.
And the chronology I set out in my introduction.
Mm-hmm.
The appellant underwent a screening interview and a substantive interview. And I won't take the court to those because what matters is essentially the substantive findings that followed, or the conclusion of the respondent and then of the tribunal. So the appellant relied on a letter from the MQM, and there were a series of such letters. This is the one at page 105 in the supplementary bundle. And from officials of the organisation to say, often in relatively brief terms, that the appellant is a member, and from 2018 is described as having become a committee member.
Yes.
The starting point, effectively, is the Secretary of State's first decision in relation to WAS, which the court have at page 195.
Mm-hmm. Of the
core bundle.
yeah.
So it said there, and his claim is summarized on page 196. Included in the summary, you joined the MQM age 16 in September 2009, item 14. You were a general member of the MQM. No problems in Pakistan before coming to the UK. You joined the UK branch of the MQM in 2014. You were a general member of the party in the UK. You attended MQM programs and 4 protests in the UK. Power 20. And then he was saying that unknown people had visited the family home in Pakistan. And that's a part of the claim that's rejected by the Secretary of State, and that's upheld.
So I've lost where you're reading from now.
Para 21 on 197, I think, was you were
Yes.
talking about what happened
And then the decision moves to what's called the material facts consideration, page 199. Paragraph 38 is setting out an assessment of the claim. You claim you became interested in the MQM part in September 09 because you love the leader of.
Just a moment. We're at paragraph 37 and 199.
Paragraph 38.
We're on the core bundle. So did I. We're just finding our way. Just give us a moment, Mr. Fripp, please. So we're on paragraph 38 of the decision letter.
Yes.
Under the heading Material Facts Consideration, MGM Membership and Activities, on page 199 of the core bundle.
Yes.
Thank you.
So that's setting out the claim. And then the key issue here is what the Secretary of State makes of his claim to membership in the MQM, and that's at paragraph 41 on page 200. You were...
And the conclusion, line 6, therefore.
Yeah.
Yes.
Therefore, your knowledge of the party is consistent with your claim. Therefore, you've been interested since you joined in 2009. Therefore, it's accepted you're a general member of the MQM party. Some other micro-references, if I may, that go to this issue of where demonstrations were taking place. Paragraph 45, page 201, identifies the first protest the appellant says he attended as being outside 10 Downing Street,
yes.
so not the... And then paragraph 48, you claim the next protest you had attended was outside the Pakistan High Commission. You've provided photographs of the protest in support of your claim. However, they state that the protest outside the Pakistan Embassy in London took place on 10 September 2018. These conflicting accounts further damage your credibility. There's an account of, and then paragraph 49, 2 further protests, 10 Downing Street. And in essence, what is accepted is membership, but what is rejected is the claim that the Pakistani authorities visited his home. That, in part of his account, is rejected by the Secretary of State. And that, in a nutshell, is at paragraph 61 on page 205. And then we move, to the...
I'm sorry, forgive me. Paragraph number again, I missed that.
61.
Thank you very much.
I'm so sorry.
No, it's my fault.
head
I
down
was
reading.
just thinking of something else. Rejected the claim that Pakistan authorities had visited his family home in that country. Yes, thank you. Right?
Yes, and then it goes to Judge Scahan. If I'm... Judge Scahan, and this is at page 183 in the core bundle.
Yes.
At page 188, Judge Scahan records that the Home Office representative relied on the reasons for refusal letter that you've just seen. And that is, of course, the letter that expressly accepts the appellant had been a member of MQM since 2009 in Pakistan.
I'm so sorry, Mr. Fritz, my fault. Which paragraph was that,
8.
please? 8, thank you.
8.
Middle of page 188.
Thank you.
First sentence.
Yep.
Judge Scahan's findings and decision are set out beginning on page 190. I first considered the timing of the asylum application.
190, just to get them all getting there. Bottom of paragraph 11.
Yes, paragraph 11. So paragraph 11 is important. The second sentence, the appellant was an active member of the NQM in Pakistan for approximately 3 years from 09 to 12, prior to his arrival in the UK, and the judge found the father as a supporter of NQM. In December 2015, the judge says the appellant had been an active member of NQM for 6 years overall, and NQM London for approximately 3.5 years. But the judge goes on, it's difficult to identify any real change of circumstances relating to his political activities that triggered his asylum application. And then the judge didn't accept the Pakistani authorities to be aware of him. Because of the stage of proceedings, I don't need to ask the court to take that any further. That was simply a finding at that time on the evidence. As to the incident claimed regarding the appellant's father, it said there's no corroborating evidence in relation to this, para 13, page 191.
Mm-hmm.
And so the judge accepted, and this is para 16, which extends across pages 192 and 193.
Shall we just read this paragraph?
I'm grateful.
Thank you.
Malad, I draw particular attention to the judge's finding. I accept he's a current member of NQM, likely to continue to be a supporter of NQM. Should he return to Pakistan, I accept he shouldn't be expected to lie or conceal his political opinion. He doesn't claim to be a senior member of NQM. And in essence, his claim fails. He's not a senior member. There's no evidence of a profile that the judge considers gives rise to any risk. And he's disbelieved, or rather, his account of his father being approached isn't accepted. But an important point running through the determination and through the process is that there's no general finding that he isn't a witness of truth. That is, there's no overriding finding that he can't be trusted, save on specified events. And there's clearly a balance. And there had been an acceptance by the Secretary of State. He'd been a member in Pakistan since 2009, when he was 15 or 16. And that was accepted, evidently accepted and adopted by FTTJ Scayan. And the appellant sought and was granted permission to appeal, and I shan't divert from the main course, but his appeal failed. It was found that Upper Tribunal Scayan's decision was not undermined by any material error of law, and so that is a decision that has the protection of devacelen, that has a devacelen status. That has a devacelen status,
yes.
By which I mean that represents, or should represent, a starting point for what comes
yes.
Now, Malad, let me move on to
the renewed claim.
The renewed claim. The appellant.
So, Mr. Frick, can I ask you a question about the hearing in front of Judge Henderson in the first tier? The appellant was represented by counsel. There's no reference to devacelen. Was it argued by the appellant that any of the findings in the first tier tribunal decision by Judge Skean should be taken as a starting point by first tier Judge
Well,
Henderson?
maybe, that may be because it was the respondent's case that Judge Skean was the starting point before Judge
Right.
Henderson. That's at para 13
Of Judge Henderson.
of Judge Henderson,
Right.
page 128. So there wasn't any contest before Judge Henderson, and this may be why the, as it were, the markers are relatively faint, but it's
Right.
the respondent's position that the starting point is Judge Skean's findings.
Right.
And Judge Skean had, as it were, accepted and adopted the Secretary of State's acceptance of membership since 2009, which we say is a highly important matter, in particular going to the second ground. So it comes before Judge Henderson. The court had this at page 126 in the core bundle. The
Positive Judge Henderson does refer to debt asylum in paragraph 13.
He does.
yes,
But so that's a summary of the reasons for refusal letter. So the reasons for refusal letter is essentially saying these early tribunals have found he was a low level member, wouldn't be at risk on return, not identifiable from his Facebook profile. So those are the features of the early determinations on which the Secretary of State was relying. The Secretary of State wasn't saying every single finding made by Judge Skean is your starting point.
no, I mean there's an extremely short summary in Judge Henderson, because it doesn't appear to be a matter of contest between the parties that Judge Skean provides the starting point, and Judge Skean's findings, and the court has seen. So that at page 128 was the respondent's position, pointing to Judge Skean as the starting point. That doesn't appear to have been opposed by the appellant. So the Judge Henderson noted the issues on appeal, page 129, and I have to accept those included the appellants in the first bullet point, para 22, on page 129. The appellant's credibility generally was listed as an issue for determination. Of course, that can be read in different ways.
What can?
The appellant's credibility generally, because that can be about whether there's a divided finding and some is accepted, some is rejected. That's a general finding on credibility. Or whether someone is generally not a witness of truth, or generally a witness of truth the other way. So, conduct of the hearing. There was someone there, para 24. I don't seek to make much of this, but there was someone there from the MQM UK organising committee, because subsequently the UT complained that there's no one there from the committee to tell them about this from the point of view of the MQML leadership. So that's at para 24, page 130. The evidence and finding. So the appellant's evidence is identified at para 28. He reiterates his life is at risk. He disputes the conclusion he's a low-level MQM supporter. He says he was an active member, and he maintained that he had a personal Facebook account which contained political content that would endanger him. My lord, if I can deal with it briefly, he raised the issue of threats to his family in Pakistan, and that was rejected. There was a negative finding of credibility as regards that, but that was specific to that part of his factual claim. That's at paras 29 through 32, pages 131 to 132. It's the final sentence of para 32 I did not find the appellant to be a credible witness on this matter. So there's no finding here that the appellant isn't a witness of truth in relation to other matters or generally. But he's not, it's not accepted that there's been events in Pakistan that he is playing.
Well,
And then,
you're going to come on to
yes, I'll come on to political...
the other finding about credibility,
Yes.
39.
Yes. Now,
Not credible about his activities in the UK.
his political activities in the UK.
So those were the two. So on those two quite substantial issues in the case, the upper tribunal found him not to be credible.
That's the division that Judge Henderson makes, that she makes. So the appellant's political activities in the UK, if I can just move through microphones, the penultimate sentence
Of
para 33, 132, as to photographs of him at Downing Street in the demonstration, there's no evidence produced to show that these have come to the attention of the authorities in Pakistan. And they all occurred after January 2018, when his father had been questioned by the authorities. Well,
that's a reference to the Downing Street photographs.
Yes. And she said, I find that the photographs do not show that he has, this is para 34, any significant political or activist role. But this isn't a general finding. It's very important to read on and see what she seems to have meant. And this is an aspect of her finding that led to the determination being partly overturned. In support of this finding, I note that the gentleman from the party described the appellant's role for MQM London as engaged with different units in the UK to organise events, preparing banners, arranging donations. The list follows. He noted that the appellant was a committee member for the North London unit. However, that gentleman also confirmed that he had no knowledge of the appellant making any political speeches or statements on behalf of MQM London. And so the judge notes paragraph 35, the appellant had said he joined MQM in 2009, but had joined MQM London in 2016. He accepted he'd come to the UK in 2012, initially had been too busy to participate till 2016 after he'd been refused leave to remain. Then you get to the Facebook profile. It was accepted that this was his Facebook account, paragraph 36. However, the evidence indicated no political content. There was a birthday message to Mr. Hussain, which would be Mr. Altaf Hussain, but there was no political content in the message. There were other messages in Urdu. Para 38 is just about the division of the MQM to the two groups. And finally, the appellant is being asked how he supports himself. He says he's been unable to work, friends supported him, he was went through, and this goes on. Appellant did not name his friend, no evidence from his friend. The appellant said he received no financial help from his family whatsoever. I did not find the appellant's evidence on this matter to be credible. So that finding of 39
is defined to, you say, is confined to what is in
yes.
39, but there are a number of, you've helpfully taken us through a number of other observations made in this section on the appellant's political activities in the UK.
Yes.
Do you challenge those?
Well,
and if so, how?
If let me bring the court to conclusion, because there's a conclusion on the heading of the appellant's
part of my question. Conclusion.
And so the first sentence of paragraph 50, I accept is important. I didn't find him to be a credible witness on several key matters relating to his appeal. And what's important in my respectful submission is that that's not, again, an overarching finding, but it's enumerating. It's indicating that matters have been rejected and that those have been enumerated.
I don't,
These are set out in detail. So
you say that's not a general finding of credibility?
It's not a general finding of credibility, and such is confirmed, in other words, on several key matters. These are set out in detail above.
In other words, you're saying, she's making findings about credibility, but only to the extent that she said so expressly.
Exactly,
Okay.
lady. And the judge in paragraph 51 says, in summary, I accept the appellant has shown that he is a member of NQML and is a committee member of the North London unit. He's an active member, the judge says. He attends meetings and some demonstrations. However, I've not found on the lower standard of proof that he's active politically in NQM London. This was confirmed by his own witness, Mr. H, who was not aware of the appellant making any political speeches or public statements on behalf of NQM London. And so, my lady, the judge there was treating political activity as restricted to, we would say, and the determination was set aside in part, as restricted to making speeches or public statements on behalf of the group, rather than involvement in the organisation and attendance at
Well,
events.
the determination was set aside completely. What happened was that some of the findings, factual findings, are preserved, which
Yes.
is rather different.
Yes, that it came before Upper Tribunal Judge Bloom. The court has this at page 102. The criticism of the judgment of Judge Henderson I can leave. The preserved findings are listed in para 21 by Upper Tribunal Judge Bloom, page 107. There has been no challenge to the judge's adverse credibility findings. The judge's findings of fact relating to threats to his family in Pakistan are preserved, so that's rejected, as is the finding of fact at 39 relating to his receipt of financial support. The judge's factual findings in respect to the appellant's level of involvement with the NQM London and Facebook are also preserved insofar as they relate to the store class activities. If I might just draw the court's attention to something that otherwise might be hidden in para 20. And it's para 20, it looks like about line 9. It begins near the end of the line, and the sentence reads, although the judge found some aspects of the appellant's account incredible, he did not make any express finding that the appellant's involvement in NQM London was not genuine.
So what?
Well,
Because the determination is set aside.
yes, the determination
So it's for the upper tribunal to remake the decision,
yes,
subject to the preserved findings of fact.
yes, and the preserved findings of fact are carefully enumerated. They've been enumerated by the judge and they're enumerated by the UT.
Yeah.
And then the matter comes back, and this brings the court to the determination under appeal, the rehearing. Beginning at page 59. There's a summary of the matter looking at Judge Scahan. This is page 60, para 2. Judge Scahan found that the appellant wasn't as integrated with NQM London as he claimed to be. And that's quite a vague statement, and the tribunal has seen what Judge Scahan found. The judge accepted he was a member of NQM and would continue to support NQM P, that is likely an error for NQML in the event of his return to Pakistan, because the tribunal's seen the original reference. That doesn't say he'd support, as it were, the other faction. Judge Henderson is referred to at para 4. Judge Henderson did not find the appellant credible. Now, that's not expressed as a qualified statement, but that's not actually loyal to the way the findings Judge Henderson had made, which were...
But why does that matter? His decision's been set aside. Oh, sorry, her decision's been set aside.
Yeah, well, because credibility findings were preserved, albeit those credibility findings are themselves, as it were, enumerated.
Yes, they are particularised in paragraph
Yeah.
5,
Exactly.
where there's a citation from paragraph 21
Yes, and so...
of Judge Bloom's decision.
Yes.
So there's no doubt about what credibility findings are preserved.
Yes. And so, well, para 4...
So what you're saying is that we shouldn't read paragraph 4 as reading Judge Henderson didn't find the appellant credible at all,
No.
but
no,
in a number of respects.
yes.
Right, thank you.
There's reference to the appellant's evidence, which included page 63, para 15, being a member since 2009 and becoming more heavily involved in 2016. Then there's an account of the submissions. Let me move to page 72, section D of the decision, which is heading Assessment. It said, as we understand it, the Secretary of State's primary submission, low-level members of MQML would not be at risk on return. However, also Secretary of State's case, that claims the authorities would be, aware of the appellant's low-level activities and his return are unduly speculative. Moreover, his limited activities would not have come to the attention of the authorities via social media surveillance. And furthermore, as he's not a genuine supporter, he would switch allegiance without engaging HJ Iran in any event. They had evidence of a journalist, Dr. Bennett Jones. They deal with, at some length, with one matter, which is Dr. Bennett Jones's evidence that there's systematic underreporting, because in essence it's dangerous to report on acts against MQML or Altaf Hussein supporters in Pakistan. That's accepted by the tribunal at para 72, page 74. At para 77, page 75, noting the context behind the evidence of Dr. Bennett Jones, there's reference to the political history, and we accept that after Altaf Hussein's speech in 2016, the background evidence supports a general and effective indiscriminatory clampdown on MQM activity. It was reported that the violence brought the full force of the Pakistani state crashing on the MQM's head, and that in Karachi, the Rangers are the Pakistan Army's paramilitary gendarmerie. The Army and Pakistan intelligence agencies began another anti-crime operation to end its political dominance. And para 78 refers again to the Army through the Rangers and the ISI, the intelligence service, targeting MQM after the 2018 speech. Para 81, page 76, what emerges is that there are a number of arrests and killings by the authorities of MQML members described as hitmen or target killers, and those holding positions of significance within the organization in 2019, 2020, 2021. Para 83, at the bottom of page 76, the overall picture from the newspaper report suggests that those perceived as criminals and described as workers within MQML are being targeted by the authorities and prosecuted. That rolls on. Para 84, our starting point is that we're satisfied that Pakistani law enforcement agencies, including the security forces, are responsible for human rights abuses, including detention without charge, extrajudicial killings, and enforced disappearances. That's developed. Para 86, the background evidence supports the use of military courts in addition to criminal courts as against this class. They've referenced various reports. I can move forward from the digest of the human rights material. Para 94, page 81. Whilst there are likely to have been more arrests and convictions than reported, there are reasons which we find explain why, in the light of the targeting of NQNL supported members, there's a lack of evidence of widespread reporting of arrests and convictions, and why the evidence focuses on target killers, serious criminals. 95, we accept that many supporters have aligned themselves with NQMP, which is the new faction in Pakistan. They note further down this paragraph, there are, from what we can see, legitimate reasons for wanting distance from Altaf Hussain. However, we accept that in some circumstances, the sole motivation is self-preservation. The evidence generally supports that Pakistani armed forces have been involved in serious human rights violations as part of their counterterrorism operation to clamp down on supporters of Altaf Hussain. However, we find it's reasonably likely that the threat has led to a decrease in those who are willing to admit allegiance to NQNL, and those identified by the authorities as a threat. At 96, there was no challenge to Dr. Bennett Jones's evidence concerning ability to save oneself by changing allegiance. No direct support for it, but this isn't very surprising because of the nature of the evidence and the tight control of the media. The evidence about switching allegiance is logical. The authorities don't want to crush MQM's power base. It seeks to eliminate Altaf Hussain and his power base. The tribunal, across on page 82, para 100, notes there is no evidence from either party about returned supporters or members. This initially caused us concern. However, this may be explained by what Dr. Bennett Jones said about being able to avoid this by renouncing support and giving information to the authorities. It accords with the state's intention to eliminate Altaf Hussain's power base while maintaining MQMP. Having considered all the evidence, we accept that there's an option available to some members or supporters of MQML who come to the attention of authorities to avoid ill treatment by renouncing AH and giving information to the authorities. However, we're not suggesting this is available to those who genuinely support AH, as this would breach the HJ Iran principles, but rather a practical option, which may nevertheless entitle a genuine supporter to refugee protection. 101, it's noted that the description of target killers may be a pejorative or misleading characterization of individuals who are victims of the army or the Rangers, who are killed for support or perceived support for Altaf Hussain. That is, they're essentially people killed in encounter killings, and it's said that they were hired killers for Altaf Hussain. 102, we accept that individuals who are identified by the Pakistani authorities as being involved with MQML, described in the background evidence as members, supporters, and workers, are targeted by the authorities. And my lady, this is why this case is really so acute, because the tribunal accepted that the nature of the interest in this organization, of the Pakistani authorities in this organization and followers of Altaf Hussain was potentially lethal. And there are really quite strong findings here about motivation and ability on the part of the Pakistani state. So, para 103.
Sums it all up.
Motivation and ability to do what, though?
To find, identify, and persecute in various
in Pakistan or in
people
the UK?
Who are, well, I mean, our case, and I think the UT accept this in part, is both. I mean, the Pakistani authorities are suppressing followers of Altaf Hussain brutally in Sindh and elsewhere in Pakistan. And that the UT accepted that.
Well, it's all summed up in 103. Yes. That's where he draws all the threads together.
Yes, that draws the threads together. and we rely on all of it.
On 103.
On 103. And
Okay. Well, we've read that.
104, 84, Dr. Bennett-Jones gave evidence about the knowledge by the authorities of activity in the UK to support his contention the authorities would be aware of a person's membership and activities. We find that there's some indirect support for this. The evidence establishes there's a campaign against MQML in...
Can we jump just to the end of this paragraph, because you don't quarrel with this paragraph, do you?
No, and...
and this rather... doesn't this undermine the relevance of the Eritrean case, so far as this case is concerned?
Yes.
Because on the fact, whatever it may be, that whether or not what Justice said he was right about in that general proposition, in this case,
yes.
The Upper Tribunal came to the conclusion that it sets out at the end of paragraph 104.
Yes,
so that's that.
And in line with the grant of permission at the initial stage, we say these findings, which haven't attracted any contrary appeal, we say these findings are so strong that in light of it, effectively, there was that pointed to the appellant being at risk. And then at the end of 104, para 104, still on page 84, the fact that Altaf Hussein is in London, in our view, makes it more likely that there is monitoring of activities here. It's entirely plausible that the security forces would invest resources on identifying genuine supporters and members overseas. It is reasonably likely, in our view, that the authorities would go to lengths to ensure that AH's power base does not gain traction in Pakistan. In context, that's obviously referring to attempts to avoid London being a base for traction regeneration in Pakistan.
And then we come to 107, which is...
Yes, well, 105,
right.
The evidence of the military. So the military have a detailed, the military have a branch that monitors communications and social media. We also take into account the evidence of the military closely and effectively, those words closely and effectively, monitoring media activity, which is supported by the background evidence. 106. The Pakistani authorities are determined to prevent the re-emergence of Altaf Hussein's power base.
Yep.
It is reasonably likely that they monitor activities of MQML on the ground. In addition, the ISPR, which is the branch of the military that follows this, effectively monitors media activity.
And then 107, it all comes together again at 107, doesn't it?
Yes, reasonably likely that if there are, well, they rather jump to the question of if the authorities know about you, you are at risk. And then it said it's reasonably likely that if they know about you and you return from London, you're going to be told to renounce your beliefs and inform on people. Whilst a non-genuine supporter member can reasonably be expected to renounce support without engaging HJ Iran, it's not reasonable to expect a person to give information about others that may or may not satisfy the actor of persecution. There's no evidence of the extent or quality of information the authorities would expect a person to give, likely to depend on the individual actor of persecution, to whom rationality cannot be attributed. Neither party grappled with the issue, but we are no doubt that any expectation that a genuine supporter or member should give information about others would be contrary to HJ Iran. The proposition any person who's not a genuine supporter but perceived as such could give information about others is entirely nebulous. What's clear to us, what is very clear to us, is that providing information in exchange for safety is fraught with risk and uncertainty. That's the tribunal accepted the range of different agents involved, the responses of different agents, the possible lack of rationality. Also present, of course, is the desire to be seen to be doing a good job against people, whatever the actual conviction of the individual and considerations of deterrence. The upper tribunal goes on, page 108, whether or not a person will be of interest to the authorities doesn't depend whether they're a member, supporter, or, quote, worker. What is critical is whether an individual is or is perceived to be pro-AH and or pro-MQML, because they've engaged in activity which is reasonably likely to have come to the attention of the authorities as a result of monitoring in the UK by the authorities and or monitoring of media activity. And then they disagree, well, with use of the phrase low level, but they had in fact heard a submission from Mr. Hogarth, who represented the respondent below, that the appellant wasn't at risk because he was low level. And the upper tribunal reject the proposition that being low level makes a difference. That is, if you're really affiliated with these people, I mean, if you're a genuine member, the UT seems to accept you're at risk if you go back to Pakistan for the reasons they give. And they're express about that in para 108. What is determinative of risk is whether pro-MQML or Hussein activity has come to the attention of the authorities, rather than categorization as low or high. However, the greater the level of activity, the more likely it would have been detected by the authorities. And the matter was before then. I mean, there are photographs in the supplementary bundle. For example, in supplementary bundle page 121, of the appellant standing next to Altaf Hussein shaking his hand.
Yes.
There are multiple photographs of the appellant with Altaf Hussein or in MQM settings.
Yes.
So do the photographs of the appellant shaking his hand relate to different occasions or the same occasion?
Well, there are several photographs on one occasion, but there are photographs of numerous occasions.
Okay. Yep.
So the upper tribunal, moving on, page 86, and I do have Lady Justice Lang's query as to where demonstration took place in the number in my mind, and I'll come to a reference which I hope will address that.
Thank you.
So the upper tribunal carry on, para 109. There's no evidence, so there's no positive evidence. The authorities have a list, implicitly a complete list, of NQML members or supporters. If this were the case, we would reasonably have expected some support for this, either in the background evidence or evidence from other NQML supporters. This does raise a question about the approach, which is that the people being surveyed may know they're being surveyed, but they're not the ones doing the surveilling, so they may be entirely unconscious, as it were, of being surveyed and not have certificates from those doing the surveilling. But moving on, 110.
Mm-hmm.
We don't accept the expert's evidence about MQM members giving information to the Pakistani authorities to curry favour gives rise to a real risk of this happening, and they go on to indicate why that is. And then a series of findings about monitoring and the attitude of the Pakistani authorities.
111, are we on that?
111.
Yes.
Something that looks back to implicitly is the evidence of Mr. Bennett Jones that was accepted on this point. And the court has it in the supplementary bundle, page 156. So supplementary bundle 156, paragraph 14, where Dr. Bennett Jones notes.
I'm just wondering,
Yes.
Mr. Grip, noticing the time and the way in which the judgment is structured, are you content for us to proceed on the basis of the summary 115, or do you? I mean, that seemed to me, what I read underlining as I was going through it yesterday, it seemed to me that 115 and 116 were really 115 here. 115 draws all those, again, use the phrase, draws the threads together, doesn't it?
Yes, I accept that. I was going to draw the court's attention to Dr. Bennett Jones, who had said the Pakistan state has an active intelligence infrastructure in the UK.
Yes.
Some intelligence officials are based in the Pakistan High Commission, others are British Pakistanis living in the UK. He said the British authorities would hope that most of these people were focused on uncovering the activities of violent jihadis planning attacks. In fact, successive Pakistani governments have been more interested in finding out about domestic political opponents active in the UK.
Okay.
And he notes in the next paragraph, the MQM is an important intelligence target for Pakistan officials. So that was part of the background, and that feeds through to what the court...
That fleshes out what he says, but
Yes.
the core points are at 115, aren't they?
Yes, and so the upper tribunal had said, para 113, we've no doubt. So the language often is quite strong evidence.
Yes.
Strong language. No doubt that security services are able to detect social media posts. Although the evidence doesn't, however, establish that it's reasonably likely that they have the resources or capability to detect all posts which mention AA. And my lord, we'd respectfully say it's an error of approach. If you have, this is rather the contrast with the YB situation, where you have evidence that this is a government which is attempting to extirpate this group and the followers of the leader of the group in Pakistan, and is targeting resources on monitoring what happens in London, where the leader of the group is based. I mean, and whether someone is at risk, in our respectful submission, it can't reasonably depend on whether the Pakistani authorities retrieve 100% rather than 50% of social media posts about Altaf Hussein
Well,
or this group in London.
okay. So looking at coming back to 115 and the conclusion,
Yes.
because it seems to me that's often, as you demonstrated, we'd already realised, quite a long exposition of these issues in the evidence about them. They draw the threads together in paragraph 115.
Yes. And
Do you quarrel with anything that's said in 115?
I don't, my lord. And,
No.
and
Right.
something that's important is that looking at, I mean, the court will be very familiar with the way in which the upper tribunal often puts things in country guidance. This determination was prepared in a way to make it suitable for country guidance. The upper tribunal is most reluctant to make findings as categorical as those at 115.
They're most reluctant to make findings as categorical as they have in this case.
Those are highly strong findings
Yes,
compared
yes.
to London.
Well, that's
Um,
what Mr. Hoban says. They are certainly
so
clear findings, I would have thought.
the tribunal then comes to the appellant in section E, beginning at 88.
Yes.
This is important, looking to both of the grounds. We remind us, 119, we remind ourselves of the findings of the FTT, which have been preserved. So the starting point there for the upper tribunal is in fact, not FTTJ Skein, although the tribunal had recorded at the start of this very long determination that the starting point actually was FTTG Skein.
Well, no, what they'd recorded, what they referred to was the reasons for refusal letter. They hadn't directed themselves that was their starting point.
They had,
maybe I've misread paragraph 13. I thought that was just a summary of the reasons for refusal letter.
Well, there's reference, I accept, to Judge Skein. They don't say in terms of para 2 that Judge Skein is the starting point.
Okay.
As a matter of...
Well, did you submit that Judge Skein was the starting point?
Well, Judge Skein is the starting point.
I know, but you represented the appellant. Did you say Judge Skein is the starting point, and in particular his finding that he's been a member since 2009?
Well, the findings of Judge Skein represent the starting point for the case, and it was our case that he'd been a member of 2009 as accepted.
You haven't answered my question. You haven't answered my question. Did you expressly submit to the upper tribunal, we rely on Judge Skein's finding that he was a member from 2009 onwards?
Well, that was our case, my lady.
Okay. We've heard how you put it. We're at 119.
119, we remind ourselves of the findings of the FTT, which have been preserved. That's FTT-J Henderson. So the appellant is not a credible witness on key matters relating to his appeal. Now, that's 1191, page 88. That could be read two ways. It could be read as it were, a swindling finding. He's not to be believed on any key matter relating to his appeal. But the court has seen what findings that there.
This is a summary, isn't it, of what the FTT found?
Yes, this is.
So the use of the word is in that context.
Yes.
It all depends what the word is.
Summary. But the court has seen that there was an enumeration of certain matters which were rejected and certain matters which were accepted. There was no general finding as to the individual's truthfulness or
Well, that sentence, the appellant is not a credible witness on key matters relating to the appeal, is a paraphrase of something we looked at half an hour ago.
Yes.
So
it's an accurate paraphrase.
Paragraph 50 of
yes, it's accurate in that it looks to the intervention in Pakistan, which was rejected, and the financial assistance, which was rejected, and
okay, all right. I mean, I think, for my part, I don't know that I'm at the moment persuaded that that there's any sort of elision or expansion of the credibility finding, but just to flag up my thinking, Mr. Fripper, it's helpful, but that's no doubt what you're going to come on to.
Well, I'm grateful. And then para 120.
Yeah, well, do you quarrel with anything else in 119 about that summary?
Well, small room 4, there's a degree of judgment about what the photos do show. But I accept that there are photos, and there had been the judgment that they didn't show a significant activist role, although that's because Judge Henderson had taken the view that political activity only meant giving speeches and issuing statements for the
Okay, well, all right. So we wanted to go to 120 now.
120.
Now we come back to credibility.
Yes. The appellant has been found, so it's not we find, but the appellant has been found to be a witness lacking credibility. So that seems to come off
Next sentence.
in the view.
Well, that's going to be read.
Next sentence.
Aspects of his account were rejected by the FTT. We find that the appellant has exaggerated his involvement with MQM. Now,
Okay,
we're
just
not-
pause. I'm sorry to, please forgive me for interrupting, Mr. Fripp. I just wanted if I may, just focus on this 120. Focus on the.
Yes.
I read those two sentences, the first sentence, 120 together.
Yes. Well, I fully accept the second sentence, and so I accept the two read together.
It's sort of saying, isn't it? Aspects of his account have been rejected by the FTT, and therefore there is a. Well, how would you put it? What would you say is an accurate? If you want to rephrase what the first sentence, how would you put it?
Well, the FTT had rejected, I mean, most clearly, the financial support issue, para 39 of the previous determination, and any assertion that there had been the Pakistani authorities approaching the family in Pakistan, roundly rejected those aspects of the claim. And
All of which was cited earlier in the judgment.
yes,
Judgment.
yes. So I accept that there certainly
Okay.
were
All right. Well, maybe we've dealt with that point.
Yeah. He's exaggerated his involvement with MQM.
That's this is this tribunal's finding.
Yes.
Is that right?
Well, it's not quite clear.
Well, it says we find.
Yes, it says we find. It's not following any course. It's following various references to what is as it were baked in, rather than a course of reasoning supporting a finding. but it's not very clear what
Well,
exaggeration is.
doesn't
meant
it?
anyway.
I mean, we doesn't. One could say that sentence should come later on, because doesn't it link to what follows on? And after that, we find that he's exaggerated his involvement with MQML.
Yes.
It's a sort of executive summary of what they go on to deal with, isn't it?
Yes.
And the reasons why they found it, I mean, I'm putting this badly, forgive me, Mr. Fripp, but the basis upon which they make that broader assertion are the following sentences. Isn't that right? We weren't satisfied that he was involved with MQM before he came to the UK in 2012. We don't accept he became a member before 2016. And then etc., etc., etc.
Yeah.
And it's on that basis that they find he's exaggerated his involvement with MQML. And then they repeat that, 4 lines from the bottom of that paragraph.
The rest of it is quite important, because although they say we don't accept he became a member before 2016, I mean, they don't deal with Skahan there, or with the Secretary of State's position in the first refusal letter. They say, we take into account he may have supported MQM before the split in 2016. This is supported by the pre-2016 Facebook posts. So this is quite important, in particular going to the second issue, because the appellant was supporting this group at a time when he had no reason to do so, to try to build an asylum case. For years, some years before he ceased to have leave to remain, and 4 years before he claimed asylum, then that's a significant matter.
I mean, isn't it in essence what they're saying? Yes, he had some sympathy with MQM. Yes, he was interested in it and was following it in some way previously, but he's exaggerated the extent of his involvement to bolster his claim. That's. I don't think that's inaccurate. It may be crudely put.
Well, that supports my case, respectfully, on the second ground, because that's an account of someone who is a member or is associated with the view, and not someone who is not a genuine member, in respect of whom there is, in essence, a masquerade. I mean, everything here is consistent with this not being a masquerade, but the court will find that the tribunal rather jumped to that in a section we'll come to.
Okay.
And so that's why this paragraph is very important, because
Yeah,
it's quite tightly packed. And in the middle of it, very easy to skip over with the eye, is this acceptance of support for MQM. Support for MQM means he's engaged with MQM's goals. And that's not consistent with him not being a genuine member, unless something has substantially changed and he's ceased to support the goals. So this is supported. They quote the evidence that supports that, the Facebook post. However, the evidence does not support the kind of political commitment to the party suggested by the appellant. Well, that's a little bit vague, but the tribunal found itself that anyone known to be associated with the party is at risk. And then we find that he joined MQML in 2016 before he claimed asylum on 19th of October 2017. We find that much of his evidence is exaggerated or unsupported. He's used membership of MQML to bolster his claim. Yeah. And he raised at the hearing for the first time that his aunt and nephew were killed in 1988, which was a pogrom against Sindhi people by another ethnic group in Sindh. We find that this is a recent fabrication designed to embellish his account, but they do find that he was supporting its goals before 2016, and that's very important, filtering through later to where we're going to come to.
But they don't say, they say before the split in 2016, they don't identify how much before the split in 2016.
Well, that's a reference to para 141.
Right.
photographs in social media.
All right.
I'll deal with this out of sequence. But so there's reference to social media evidence. Mr. Holborn accepted the Facebook account belongs to the appellant. They say we've considered all the evidence. We've not been given or shown any evidence that the Facebook account is in the public domain or whether he's used privacy settings. In any event, we're not satisfied he'd be identified from this account. There's nothing obvious linking the name of the account to the appellant. There is a picture of the appellant on the profile. It is not clear when this was added.
Oh, I see. Okay, I've read down
Yes,
to
the posts are limited. Somewhere in 2013, these established nothing more than that the appellant was at that time a supporter of NQM and AA before the split.
Okay.
We cannot see activity relating, and then it says...
So there's no activity between 2013 and 2019?
Yeah, and the poster from someone who clearly supports the organisation. So they express doubt as to whether that's in the public domain, which is something they're entitled to express doubt about. I don't seek to attack that, but they find that there was self-expression going on his Facebook page in 2013, which was supportive of Al Hussein and of NQM. And we say that that undercuts and will have to be explained for the UT then to make a sustainable finding that this is someone who isn't a genuine member at all, who has no genuine attachment to the organisation, its leader or its aims. And that's the second ground. I'm very conscious of the time.
Yes.
And
well,
so I will move on from the appellant rule. The point raised by Lady Justice Laing, I've been slow to come back to because I was seeking to deal with it in sequence, but I've come out of sequence and I'll bring...
you've got to go back a bit.
Well, I can point to paragraph 138, which is addresses Lady Justice Laing.
Demonstrations, yes.
Thank you.
Demonstrations. And I'm sorry it's taken me so long to reach this.
Well, don't worry, we've
It's all
interrupted
right.
you quite a bit, and it's a
I've-
very long judgment.
I've read it. It's the third sentence of paragraph 138. Thank
Yes.
you.
So
Okay.
4 on Downing Street, 1 in front of the Pakistan High Commission.
Yeah, right, okay.
Yep.
Got that.
And then, so the tribunal has dealt with social media and messaging, and then implicitly they come to this issue of whether he's a genuine supporter or not a genuine supporter, which they've identified as an issue. And they come to it at para 146, really close to the end of the determination, page 94.
Yeah.
They say the appellant has exaggerated his evidence. He is not a credible witness. Well, my observation, which I shan't labour, is that both of those are sustainable statements, but they're very general statements. So they're not true, as it were, of the whole detail of the case, because a lot has been accepted.
So your point is the next sentence is wrong because you've just shown us the material that suggests he was posting MQM type stuff in 2013.
Yes, I mean,
Okay,
he's a supporter, not a member at
Yeah.
that time,
Okay.
according to, yeah, he's a supporter, not a member in 2013 onwards. But he is a supporter. The letter from MQM states he's been a member since 2009, but we place limited reliance on this. We find he's not established genuine commitment. So there is no dealing with the first refusal, where the Secretary of State said, well, you know, we sat you down and we asked you questions in detail about this organisation, and what you told us in answer to our questions has given us sufficient evidence to conclude you are a member and have been a member since 2009. That was the Secretary of State's position in the initial refusal.
But the question that we're engaged with at this point is whether or not the appellant is genuinely committed to MQML as opposed to MQM, in the context of considering whether or not on return he would be willing to renounce MQML
my lord, I accept that. If they're, given that they're saying that there, they reach that without reference to the fact that the Secretary of State originally accepted he'd been a member since 2009, when he was 15 or 16.
No, there wasn't MQML, didn't exist in 2009.
And the 2013 references.
They didn't exist then either.
No, but that's a reference to loyalty not just to MQM, but to AH. Yeah. And AH is MQML now. And so there's certainly something that has to be dealt with. And we say that there's just no adequate basis to come to a conclusion here where there's been no finding before that he's not a genuine supporter.
Yes, they did hear evidence from him.
Well, they did hear evidence, but there's nothing in his evidence that said to show he's not a genuine supporter.
Well, it's an inference they drew from the totality of his evidence.
Well, they don't say that. There's just this very short nub at the end of the determination, and they just don't say enough. They just don't.
But it is. I mean, do you agree with my observation? Forgive the interruption. It is an inference that they draw from the totality of his evidence.
Well, it's a difficult assessment to make. I mean, that's noted in one of the decisions, A, about religious conversion, trying to judge what's in the mind of someone.
But isn't that something that the tribunal has to do in these cases?
Well, they haven't set out they haven't set out any significant reasoning about that, and they have, and insofar as
there's a lot of reasoning about the confused and nebulous evidence about his role, and different people saying different things about what his role was. I mean, isn't that an example of the kind of analysis of the evidence that might lead them to draw that inference?
Well, Milady, that might go to exaggeration of his role, but it doesn't go to genuineness of commitment.
But why would it be exaggerated? I mean, oh, all right.
Right, I think we need an eye on the clock. We have interrupted a lot. I don't think that's... I hope that's... it's not surprising in this case with so much detailed material to go through. Do you think you'll be able to finish by 1 o'clock?
I certainly will. I mean, many of the points I've alluded to, and I shan't need to...
Yes, well, I hope we've not, through our interruptions, steered you away from the very clear chart you had for your submission. So,
well, my lad, it's always helpful to
be able
to address concerns.
The way the court's worried about. Yes, I know.
My lad, moving to the submission, the final section.
Yes.
The grounds. So,
well, before you get there, have you finished? Is there anything else you wanted to say? We've more or less got to the end, haven't we?
Yes.
The judgment. Fine.
I mean,
okay.
Really, 147 follows from 146.
Yeah.
The nub is 146. 147 is an echo, and then the description.
Yeah.
The
so submissions, your case.
Submissions. The court has seen. This is the case where the UT made those very extensive findings about the strong interest and motivation of the Pakistani authorities and their capacity. And that is summarized at 115. Where those are really strong findings about the risk. But what matters is not just the strong finding about risk to someone who's known, but the findings that precede it, as was noted by the court in granting permission. The conclusions of the UT at 114 and 108, and then onwards, 111 and about the focus of the authorities on London, which is the base of Altaf Hussein, 104. The tribunal say the military closely and effectively monitors media activity, 105. The authorities are determined to prevent the re-emergence of Altaf Hussein, his power base. So they monitor MQML on the ground. In addition, they monitor media activity. And then they shift to the risk question, but they return to the activity of the authorities, issue 111. Reasonably likely they intend to monitor MQML. They attempt to monitor MQML, are reasonably likely to attend MQML meetings, events, when aware of such activity taking place, when able to attend covertly. But there are, and the reservations that they wouldn't know about every meeting, they wouldn't attend every meeting, they wouldn't know about every media post, or read every media post, respectively at 111, 113, and no positive evidence about the full extent of the level of and mechanics of monitoring Para 112. Those are limiting elements, but overall, given the low standard of proof and the anxious scrutiny that applies to assessing risk in these cases, in my respectful submission, the findings were more than enough to demonstrate that someone who, for now a substantial number of years, has been a member and then a committee member of MQML, where there are photographs and some documents in public linking him to MQML, when he'd been outside Downing Street several times and been outside the High Commission on one occasion, according to the evidence. There is, in my respectful submission, it's not a legal term, but there's a disconnect. There's an irreconcilability between what the tribunals say about the mechanism and determination that the authorities have, and the conclusion that the appellant isn't even reasonably likely to be at risk. So it wasn't the civil standard they had to apply. It was the considerably lower reasonably likely standard, and they had to do so applying anxious scrutiny, given that they'd accepted anyone who's identified as a member of this group or a supporter of the group.
Well, at the end of the day, what you say is that they say that the Pakistani security forces are looking for members of this group. He is a member and wasn't hiding it.
Yes.
In fact,
Yes.
was, in occasions, was publicly displaying it.
Yes.
So they say, you say, how can you say there is no reasonable likelihood that it comes to their attention? That's the end. That's the be-all and end-all.
Yes. Yes. Well, I'm very grateful. I respectfully accept that. And it's, well, there's both analogy and difference with YB Eritrea, because here, in a YB Eritrea situation, there's no evidence at all. There's even anyone inside, as it were, the Eritrean consulate.
Well, on the findings of the upper tribunal, YB Eritrea is irrelevant, isn't it?
Well, there are very strong findings here in this case. Perhaps I shouldn't have strayed in the limited time remaining to YB Eritrea. But as my Lord Justice Phillips has indicated, my case is that he is a member of this organisation. He's not trying to hide it. He's visible in various respects. He's engaged in activities that would have been visible. To say, well, before we can accept that gives rise to a reasonable likelihood of risk requires you to show that every social media post is processed by the Pakistan intelligence authorities is simply fettering.
Well, you say it's nothing to do with his credibility here. It's accepted that he, for example, attended demonstrations.
Yes.
It's accepted he's a member.
Yeah.
And all you say, as I understand it, is that effectively no rational tribunal could have concluded that there wasn't a reasonable likelihood that the Pakistani authorities would have spotted it.
Yes. And
that's it, isn't it?
And FTJ Henderson, in the preserved finding, doesn't just say he's a member, but says he's an active member in the sense of administration and organisation. I mean, so he's, as it were, not just someone who's on the membership list somewhere. down in, as it were, the local party base. He's someone who's active in those respects, albeit, I mean, he's never claimed to have given a speech or issued a media communique on behalf of MQM or AA. So that is our first ground. The second ground is there had never been a finding, there was nothing in the preserved findings to say that the appellant wasn't someone who could be believed on part of his case. Indeed, he was believed on a substantial part of his case. The way things went on credibility, that some things were accepted, some things were rejected.
Yes.
Those were enumerated. So
Well, wasn't credibility something for the upper tribunal to judge on the basis of what they'd heard at the remaking hearing?
They heard his evidence, but before finding that someone who, as it were, had been through the process and about whom there were certainly some positive findings against this risk of attaching to membership, there really had to be, in my respectful submission, proper reasons addressing why someone who's been a member for this length of time, who supported the goals and the leader in 2013, who on the earlier acceptance of the Secretary of State had been a member of the, I fully accept the precursor organisation since 2009. I mean, essentially, you could say, well, you claimed asylum in 2017, and from that time you've had a motive. Even that, in my respectful submission, wouldn't be enough. You'd have to examine carefully whether that was the only motive. But certainly all the various activity and the findings and concessions relating to activity before that suggest someone who's of a mind to support the goals of this party and of a mind to support its leader, who then was Altaf Hussein and continues to be Altaf Hussein. And he goes on supporting Altaf Hussein in the context of being, well, in the same part of London as Altaf Hussein, which is North London. And so it's really, in my respectful submission, the upper tribunal never makes a bed for that finding. That's satisfactory, given the particular facts in the case. We filed, but in the interest of time, didn't come to in detail His Honour or Her Honour, I'm so sorry, I don't know which, Judge Gelbard, sitting as a High Court deputy in the A. Iran case. His Honour, I'm grateful to him.
Where's that?
The A. Iran is at...
Oh, it's 237, the
yes.
universal numbering. Okay. Okay.
This is, again, not, as it were, a proposition of law, but an observation. And we'd say it's an observation about the difficulty of issues and going to issues like legal issues like reasoning and anxious scrutiny. It's page 265 below. And here,
This is on a Judge Gilbert.
yes.
He became...
Later, Mr. Justice Gilbert.
Okay, yeah.
And
Sadly, only
He
briefly.
said Gelbart.
He's recorded, at this point, he's recorded in Manchester, sitting as a deputy.
Yeah.
And I'm so sorry, I didn't realise it was now Mr. Justice Gilbert. But para 24, not a proposition of a binding proposition of law, I accept, but attempting to delve into the difficulty of asserting someone's state of mind in terms of allegiance to a particular cause, their religion. This is a point that tends to arise relatively rarely in politics cases, and much more common in religion, specifically Christian conversion cases. And such was the case there in the A case. And His Honour, as he was, indicates what appears to have impressed the immigration judge, then the Home Secretary, is that the claimant's conversion to Christianity was not regarded by him as genuine. and had been manufactured to a certain extent. It's a dangerous thing for anyone, and perhaps especially a judge, to peer into what some call a man or woman's soul to assess whether professed faith was genuinely held, especially not when it was and is agreed that she was and is a frequent participant in church services. It's a type of judicial activity very popular some centuries ago in some fora, but rather rarely exercised today. And it continues. It's about the difficulty of reaching firm conclusions about a professed.
It does go on to say, I accept such judicial boldness as this judge showed does not necessarily undermine a decision in law if he does so, and his decision was not successfully appealed.
Well, the first appearance of the first expression of any decision that the appellant isn't a genuine member, if one accepts that as meaning he's not a genuine member at all, which is why he doesn't get home on HJ Iran, in spite of the surrounding cases.
You just cite this as an elegant exposition of the difficulty in the exercise which the tribunal was engaged in.
Yes. There are others about the conversion cases.
Yeah, but the point is that it's not an error of law for them to embark on that exercise. It's just difficult.
No, I mean, there's an issue there, but it's a very difficult issue.
Yeah.
And it has to be approached with anxious scrutiny. That means really looking at everything that goes to it.
Well, it arises because that there is the further factor that is accepted on the evidence, on the expert evidence, that it's possible for someone to avoid persecution by switching,
Renouncing.
from MQML to
UMP.
Yes.
And so the issue does arise, is that something that that applying HJ Iran, this appellant can be reasonably expected to do to avoid persecution, or are they entitled to asylum? And it seems to me that issue arises fairly and squarely. And the tribunal has said, we don't think, having heard the appellant, we don't think they're actually genuinely committed. That seems to me to be a fact that they found, and that has to be overturned on the usual basis of overturning facts. And you've said why you say it should be.
They did also say that providing information in exchange for safety is fraught with risk and uncertainty. Power 107, page 5. So, I accept that the issue of his commitment was drawn, but there's just not enough here. There's not enough for there to be anxious scrutiny dealing with that critical question. If you say someone who you accept has for 6 years now, 5 years then, been a member and for 4 years a committee member of an organisation where your affiliation with that organisation, if known, means you've got a well-founded fear of persecution in Pakistan.
Was it put to him? Was it put to him that he wasn't genuinely committed?
I think, yes, I'd accept it was put. But the tribunal still had to reason its way to a conclusion. It had to reason its way to a conclusion on this very, very difficult question, which was arising for the first time.
Well, if it's put to him and he gave his answer, the tribunal was entitled not to believe the answer.
But the tribunal had to deal with the other material, with the material that pointed.
Well, they've said in clear terms they didn't think he was credible.
Well,
they've given a number of examples of where they didn't think he was credible.
Yeah, but he had been linked to. They've given a number of examples, but he'd not been found not credible as to his membership of the
At the earlier stage.
And I'm so sorry, because I come around again to, as it were, the bystaff side. But there was significant positive finding that's why the matter is before the court.
Well, now, have you finished your submissions on
I
ground
have,
two?
unless there's any matter from the bench which.
Let me just ask my colleagues, is there any matter you want to raise? Elizabeth?
Just checking my notes.
Well, thank you very much. We certainly won't hold it against you that you've taken longer than you thought you would, because we have interrupted a lot, and it's a difficult case to present, Mr. Fripp. I can see that because of the material you're working with, and if I may say so, you've put it very clearly. I'm very grateful to you, and we'll hear Mr. Holborn at 2 o'clock.
I'm grateful, Madam. Thank you.
All right.